welcome to our Foreign Excellence webinar series, which is sponsored by Black Hills IP and SLW Institute. Black Hills IP is a US-based service provider offering IP docketing, paralegal, analytics, and annuity services. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm and aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key countries. Today, we have some colleagues from FB Rice in Australia joining us to talk about Singapore. The Foreign Excellence series, webinar series is free. This is the 8th in a several monthly webinar series. The schedule and registration information can be found on the educational tab at Black Hills IP. And again, as I mentioned, today we are covering Singapore. We have allotted, there should be time at the end of the presentation to field questions. So please use the questions tab along the right-hand side of your webinar screen to enter any questions that you have during the presentation. Sorry. So my name is Greg Stark. I am a principal with the Schwegman, Lundberg, and Wissner law firm. My practice focuses on strategic portfolio development. And I am joined today by Steve Glendhill and Lee Miles from FB Rice in Australia. And I will let Stephen and Lee give you a bit of background about themselves.
Great. Thank you, Greg. And thank you for the opportunity to contribute to this webinar series. We're very happy to do so. As Australian attorneys, we are placed pretty strategically well for advising on IP issues, particularly patenting issues in the ASEAN region. We do an awful lot of work in Singapore, and we have close connections with Singapore attorneys on the ground there. So we're happy to share our experiences. By way of brief introduction, my name's Steve. I am a patent attorney in our biotechnology team here in Sydney, and I practice predominantly in the life sciences field, which is reasonably broad in terms of the technology that I cover, but generally sort of vaccines, antibodies, anything relating to genetics. And I'm joined today by my colleague Lee Miles.
Good morning or good afternoon. My name's Lee Miles. I work with Steve in the biotechnology group in the Sydney office at FB Rice. Like Steve, the practice is quite broad, focusing predominantly on therapeutics. However, I've got a background in agricultural science, and I do like to focus quite heavily on plant and animal related technologies where I can. Relevance to this talk, I've become a bit of a go-to within the firm on Singapore, having followed the recent changes in law and developments over the last 4 or 5 years, and published a few articles on the topic. So look, I'm very happy to be talking here today, and yeah, looking forward to sharing our experiences with on Singapore.
Great, thanks,
Perfect.
Lee.
Yeah, go ahead, Steve. We'll have Steve sort of give us a little intro into why we should be interested in Singapore.
Great, thank you, Greg. Yep. So why Singapore? Well, it's geographically quite strategically located in the heart of Southeast Asia. It is a very well developed economy for the region. It's close to a number of major patent filers and globally important trading partners in the ASEAN region, including China, Hong Kong, Malaysia, growing economies like Indonesia and of course Australia. Singapore is one of the ASEAN region's most developed economies. It has very well developed infrastructure, productive workforce. It has actively over the last decade or more tried to improve that infrastructure to make it more attractive globally as a place for doing business. They have a small push in biotech, and really predominantly of the last 10 years, it's developed itself as a global finance center. You'll see later in some of the statistics that the patent filings in terms of technology groups reflects that. From a business perspective, it has established itself as a major hub for multinationals in the Asia region. It's an attractive place globally to do business and to base people and companies who are interested in doing business in East Asia. It's ranked second out of 190 nations in the World Bank's Ease of Doing Business 2017. Another stat that reflects that position is that it's ranked third out of 137 nations in the Global Competitiveness Report last year, published by the World Economic Forum. It has a sophisticated but complicated IP system. It has been strengthened recently over the last 5 years or so by a number of changes in law, which we'll talk about today. And really, it's seen as being a very competent place to do business, a safe place to do business with that protection of law around it. Overall, again, because of its sophistication and its geographical position, it is seen amongst other countries as an attractive place to develop a patent filing strategy for the ASEAN region. It is a former British colony. There's still quite a bit of British influence, which is reflected in the legal system, and it still retains quite a lot of a British expat community as a result of its history. So we have a slide here showing the geographical layout of it. In the top right hand side, you can see its geographical strategic location that I've mentioned. For those not familiar with the country, it's an island country located in the northern hemisphere, very close to the equator, and it's separated from Malaysia only by a very narrow maritime border along the south of the island, around the island, called the Johor Strait. In fact, you can drive to Malaysia from Singapore via a motorway bridge or along Johor-Singapore Causeway. So there are pretty easy trade links between Singapore and Malaysia. Trade is particularly fluid, especially at the retail level. In terms of geographical size, it's very small. It's ranked 178th out of 196 countries, so one of the smallest countries in the world, despite being ranked quite highly in terms of GDP. The population of Singapore is around 6 million. It has an economy with around $297 billion GDP, an average GDP of 88,000 per capita. It is quite an affluent population as a result of the direction the Singapore government has taken the country in the last couple of decades. We mentioned the expat community, and there certainly is a drive to make Singapore a place where it is easy to live and easy to do business. It has a fantastic education structure, again, legal system, and so yes, an attractive place for particularly Western Europeans and US individuals to go and do business and set up. Culturally, it is quite diverse. It does have a number of different ethnic and religious influences. On the right-hand pie chart, you can see that 3/4 of the population is Chinese or of Chinese descent. The other major ethnic groups of Malay, Indian, and Western expats. The major languages spoken are English, Mandarin, Malay, and Tamil. And going over there, you'll find that nearly everybody speaks English as their first language, particularly in a professional environment. As I mentioned, from 1819 to 1942, Singapore was a British colony used as a trading port, and it hangs on to some of those expat historical influences. Interestingly, it has quite a large military spend. There is a sense that because of its strategic geographical location, they are quite concerned about securing their nation, and that sort of adds to the picture which we hope we're conveying of a very developed, sophisticated, reasonably affluent society and country, which again makes it very attractive for people to set up business there, and as a result, from an IP point of view, obtaining patents and having the ability to enforce patents, which we'll touch on briefly later, is an attractive option. Now, Greg, I think you were going to mention a few statistics that follow in the next slides.
Yeah, thank you, Steve. Appreciate that that background on the geography and history of Singapore. And I think the next few slides will I think bolster and bear out a lot of what Steve just described. Here, this first slide really just goes into sort of giving a market comparison between Singapore and many of the other jurisdictions, either that are important IP jurisdictions or that jurisdictions that we have talked about during this webinar series. I think the interesting things to note from this slide are that Singapore, despite being a very, very small country, has the 41st largest global economy as far as GDP goes. I think the other very interesting statistic is that their GDP per capita is second, really, at least in this slide, for the countries on this slide, only to the United States. And it really isn't very far behind the United States. So clearly a very developed economy, and thus, not surprisingly, a fairly advanced IP regime that Steve and Lee will describe to us in detail here shortly. This next slide, we start jumping into statistics around the patent system. Here we see the top 10 technologies that are patented in Singapore. I think one of the interesting things about this slide is, one, I think not surprising that it's very heavily technology focused in terms of semiconductors, computer technology, telecommunications. And then we also see, so a lot of medical and biotechnology represented there. Again, I think another indicator of the advanced economy. I think the other interesting thing is these top 10 technologies represent 64% of all applications filed in Singapore. So really, cover a large percentage of the total filings. So our next slide is going to show us the top patent assignees in the country. I think here the second largest assignee in the country is a MasterCard. I think that goes to Steve's point about Singapore being a very highly advanced financial center, a global financial center. So, with that in mind, it's maybe not surprising that MasterCard is a major filer in the jurisdiction. I think that the rest of this sort of, I think, aligns fairly well with those top 10, technology areas. We see a lot of fairly familiar names, at least for the U.S. Participants here. People like 3M, Intel, Halliburton, General Electric, that kind of thing. But we see a lot of other names like Alibaba and Huawei, are both Chinese companies. So some diversity here as well. So the next few slides are going to show us some comparisons on patent filings and grants and things between Singapore and a number of other jurisdictions, such as China, Japan, Mexico, South Korea, Canada, and Taiwan and Malaysia. And here we can see the patent filings. Clearly Singapore is much has many fewer patent filings than most of the other jurisdictions shown here outside of Malaysia. But that's probably not terribly surprising given the size of the country. Looking at patent grants, here we can see that the grants are, again, Singapore is in a similar position as to the filings in comparison to the other jurisdictions. And it's growing year over year a little bit. Patents in force. I think this is a slide that's interesting just in in more of a global sense, in that a number of the jurisdictions shown here, including China, the IP regimes are relatively young. China, for example, really didn't have a patent system before the mid 80s, and I think Singapore is somewhat similar in its age of patent system. And so here, over the years between 2012 and 2016 shown here, one interesting thing that's shown that's maybe not related to Singapore so much, but that China is catching up to Japan in its number of patents that are in force in the country. And here, as far as Singapore goes, we see them sort of nicely growing, sort of in line with the number of grants that we've seen in a previous slide. So the last slide before I hand it back over to Stephen Lee to really jump into the meat of the conversation here is one that I think is always interesting and probably a good one to think about when we're thinking about where we want to protect our intellectual property. Is what does it cost to sort of over the lifetime of a patent? Here this slide sort of breaks down the cost of a patent between the acquisition costs, so the cost it takes to sort of file and work the patent through the patent system, and then the annuities cost, sort of the cost to keep the patent in force over the lifetime. And here Singapore is sort of middle of the pack, below sort of the major jurisdictions that we see here, China, Japan, and Korea, but above some of the other jurisdictions such as Canada and Taiwan. With that, I will hand this back over to Stephen Lee to sort of jump into sort of the meat of how to develop a patent strategy, an IP strategy for both obtaining rights and enforcing those rights once they're obtained.
Great, thank you very much, Greg. And so we'll start with an overview of patent strategy, and I'll just mention that on this slide we're talking about patent strategy. In the presentation towards the end, we have a couple of slides that mention trademarks and designs. I think a bulk of our conversation today will focus on the patent strategy and the patent regime because it is quite complicated in Singapore. And so apologies if we have expectations of details on trademarks and designs if we run out of time, but we're obviously very happy to answer any particular questions on those IP rights. As I said, the patent structure of the system in Singapore is fairly complicated, and it's something that needs to be taken into careful consideration when developing your client's overall patent strategies in the ASEAN region. We generally find that there are a number of different ways that we can go about developing a strategy for this region. Again, at FB Rice, we offer an ASEAN filing hub service where we coordinate filing throughout the ASEAN region, and so we're reasonably well practiced in developing all sorts of strategies for the ASEAN region. Now, often those strategies do involve Singapore. The first cog in the machine is the question of obtaining IP rights, and again, this is particularly important for Singapore, which we will go to in detail. Figuring out what is patentable and how easy it is to obtain those claims. The question of enforcement once you've obtained those IP rights is always incredibly important. Again, we've mentioned that Singapore has a very well-established legal system, and that includes an IP system where they are competent to handle IP disputes, and they do. Due diligence always factors into the equation. We often advise on third-party patent portfolios, and again, that ties into the question of enforceability of those portfolios. There are options for invalidation of third-party patents, and so those obviously need to be taken into careful consideration. So with that said, I'll hand over to Lee to jump into the details of the patent system and start off with a consideration at a reasonably high level of some changes that have happened in the last few years.
Wonderful, thank you, Steve. So I thought I'd kick it off by going into a brief overview of the history of the patent system in Singapore. As we've alluded to in the earlier slides, there has been some recent changes. I think it's good to understand how the system has developed, understand how the current system operates, but also understanding the number of the patents that are kicking around in the system are still operating under the old Act. As Greg mentioned, Singapore has a relatively new regime. It didn't officially have its own Patents Act until fairly recently. The Patent Act and rules were only enacted in 1995 based on the UK Patents Act 1977. Singapore also became a member of the Paris Convention and the PCT at about the same time, having already become a member of WIPO in 1990. And they worked quite closely with WIPO in developing their own patent regime. For those life sciences people tuning in, also worth noting that Singapore is a party to the Budapest Treaty for the purpose of patenting microorganisms, anything that involves a biological deposit. So prior to the Patents Act that we now have, the registration of Singaporean patents was only possible via a re-registration of a granted Great Britain patent, or UK patent, or a European patent designating Great Britain. This is similar to the current registration procedure for Hong Kong via the European, UK or Chinese application. Of course, that's no longer available. Now you have to actually file directly into Singapore and prosecute your application there. Unlike a number of other jurisdictions, Singapore only has one type of patent. There's no utility or innovation patent system, just a standard patent system. The first system that they had, which came into play in 1995, was based on or operated on a self-assessment basis. This was implemented on the recommendation of WIPO to encourage foreign applicants to file into Singapore when it first established its regime. Under this self-assessment system, which I'm sure a lot of you in the room dialing in have had experience with, the decision to grant a patent ultimately rested with the applicant. That's not to say that the patent application didn't undergo examination. It just meant that following examination by the Intellectual Property Office of Singapore, an applicant could simply request grant of a patent irrespective of the outcome by paying a fee, provided that irrespective of whether the claims were deemed to be novel, inventive, or industrially applicable. So, in practice, only formal filing requirements were required to be met, appropriate fees paid, and you could obtain a granted patent. The question of validity is a different matter altogether, and it was the onus of the applicant to ensure that any issued claims were valid, a little bit like the existing South African system. So for those who have prosecuted applications under the old system, you'll recall that it was extremely complicated. It had a dual track system, a fast track and a slow track system. Within both of those tracks, there were multiple examination options, which resulted in 6 different routes that could be taken, each with differing deadlines and filing requirements. So it was extremely complicated. Recognizing that system was overly complicated, and in an effort to strengthen patents to ensure, by making sure that a substantive examination by IPOS occurred, there was an overhaul in 2014, and there's been a couple of subsequent changes to the patent system since then as well. So essentially, the patent regime has moved to what they're calling a positive assessment system, whereby only patent applications meeting the patentability criteria following substantive examination by the Intellectual Property Office of Singapore are granted. So as a result of this, the number of examination options was reduced to make the system less complicated. However, relative to most other jurisdictions, it's still recognised as being a fairly complicated system, and we'll go through some of those various examination routes shortly. Also important to note that with the changes came up there was a beefing up of the resources and capabilities at IPOS. This was in line with their intention to make Singapore a global IP hub. And recently, so they do act as a receiving office for PCT applications. They have internal searching examination capabilities, and I read recently they've also started accepting applications and searching in Chinese, which is also useful. So we'll kick on to the next slide. So as Steve mentioned, when deciding whether or not to file into Singapore, one of the most important questions is, can I get patent protection for my subject matter? What is patentable in Singapore? I think generally speaking, Singapore is a fairly lenient jurisdiction as far as patentable subject matter is concerned. It's quite similar to Europe in terms of what is and is not patentable. There are a few statutory exclusions, which most of them are not surprising. Discoveries, scientific theories and mathematical methods are excluded. Literary, dramatic, musical, artistic works are excluded. Schemes, rules or methods of performing mental acts, business methods, programs for computers are excluded. The presentation of information, methods of treatment of diagnosis performed directly on humans and animals are also excluded. The recent act also brought in an exclusion towards human reproductive cloning. Previously, Singapore was a bit of a hub for stem cell technology, and there's probably still a few patents kicking around with subject matter, with claims to that sort of subject matter. And then generally, inventions which would encourage offensive, immoral or antisocial behaviour are also excluded. So what we're left with really is the typical types of subject matter. Mechanical inventions, medical devices, computer hardware, technical software, chemistry, they're all patentable. I neglected to mention there that also antibodies, proteins, nucleic acids are also patentable. The myriad decisions that have played out in the US and Australia haven't quite touched Singapore, nor has the Ariosa decision. So that's all patentable subject matter still. Discoveries we've mentioned. Plant and animal varieties are also they're actually patentable. It's also possible to obtain protection for plant varieties through their PBR regime, which I won't touch on here, but happy to answer any questions on. And then the rest of those categories we've already gone through. So look, overall, I think it's reasonably lenient. On methods of treatment, I will just mention that even though methods of treatment and diagnosis performed on humans or animals are excluded, it's still possible to obtain first medical use claims. So if you've got novel subject matter, you can get first medical use claims if they're drafted in that EPC 2000 style. That's like a composition or a substance for use in treatment or as a medicament or in therapy. And if it's a second medical use, you can get claims in the Swiss form where you've got a substance for use in the preparation of use of a substance in the preparation of a medicament for treating a particular condition. And also on the topic of computers and business methods, you can get claims to software and business methods, provided that they address a specific problem in a technical way. So we find that the Singaporean Patent Office applies a Airtel, a UK Airtel type test. So we can address these sorts of issues during examination. All right, so let's look at the patent system at a glance, bearing in mind that they only have a standard patent system, no innovation patent system. Not surprising, the term of a standard patent is 20 years, which is consistent with other jurisdictions. But worth noting that they do have a patent term extension regime, which for pharmaceutical inventions. So you can extend a pharmaceutical patent by up to 5 years where regulatory approval limits the ability to exploit the patent. In theory, there are also provisions in law which permit patent term adjustment where there have been delays on the part of the patent office, a little bit like in the US. The difference is you actually have to actively request PTA in Singapore, and I'm actually not familiar with any successful or any cases where this has been applied for or granted. For pharmaceutical inventions, also worth noting that Singapore has data exclusivity provisions. So you may be able to extend protection using regulatory data as well. That runs from 5 years from the date that a product license is granted by Singaporean Health Services. On general patentability, no surprises. You've got novelty, inventive step, industrial applicability in line with most of the major treaties and conventions. Novelty is absolute, so any disclosures or acts anywhere in the world are considered. But Singapore does have a novelty, grace period provision for self-disclosures. These were recently broadened in the 2014 overhaul to apply to any self-disclosure within the last 12 months, where previously it was only for disclosures relating to breach of confidence or disclosures to learned societies. So quite similar to the US and other Commonwealth jurisdictions like Canada and Australia. Inventive step is assessed against what we call the modified Windsurfer or Pozzoli test. I won't go through how that test operates, but worth noting. Publication occurs at 18 months. So basically after filing, the Intellectual Property Office will publish the patent number in the official journal. If the patent's already been published in English, it won't publish the patent itself. However, if it was not published in English, it will publish an English version shortly after filing, after the filing formalities are satisfied. I think another point to note is not so much for PCT application, national phase applications from PCT, but for the local system, they don't have what we call a classic provisional filing system. They do have a pseudo provisional application where you can file an application without claim. So something that identifies or describes an invention and where you make it clear that it is intended to be an application. You can file an application and get 12 months grace to file claims to establish a complete filing date. Next slide. All right, so just looking at a couple of the filing requirements for Singaporean applications. So national phase entry deadline's 30 months, but it's good to bear in mind this can be extended by up to 18 months as of right. So you don't have to provide any reason. You just have to pay fees. It can also be done retrospectively. So generally speaking, applications must be filed in English, although as mentioned earlier, the Patent Office has started accepting PCT applications in Chinese. That occurred as of 2017. If a PCT application was not originally published in English, an English translation must be filed at the time of filing with a verification certificate, but you do have a 2 months grace period in which to file your verification certificate. Other than that, there are no formalities, no power of attorneys, no declaration, so it's quite straightforward. Once your application's received, it'll just undergo a brief formality examination, and provided that you've checked all the boxes, it's accorded filing number. If you haven't met all of the requirements, you'll be given a 2-month period to respond. So I think the takeaway message is that urgent filings are entirely possible in Singapore. Really all you need is an English application and to pay your fees. If there are any issues, you can remedy them, and you've always got that 18-month extension period if you decide to file into Singapore later. All right, this is the uncomplicated, the less complicated examination system that's in play in Singapore at the moment. So you can see it's still quite a complicated system despite recent changes. I've tried to distill the various examination options into a single table. So you can see there's 4 different options available. In reality, only 3 are typically taken up by PCT national phase applications because the first option the first deadline is too early. And in practice, what we really see is that the last two, options 3 and 4, are the ones that are most typically taken up for Singaporean national phase applications. But nevertheless, we'll go through each of them in turn because it is a complicated system and it's probably worth just stepping through the various options. So looking at option 1, that's a local search and examination by the Intellectual Property Office of Singapore. It's a 2-step process whereby searching occurs at 13 months. You file a request for searching at 13 months from the earliest priority date, and then you, based on the local search report, you request examination at 36 months. So, you know, it's not surprising this option is typically only applies to direct filings into Singapore, but for a lot of some corporates, they do file convention applications directly into Singapore and other jurisdictions, so this option may still be relevant. It's quite expensive compared to some of the other options, but it does have the advantage of giving the opportunity the applicant an opportunity to decide whether to proceed with examination depending on the results of their search report. Option 2 also involves searching and examination by IPOS, but it's a combined local search and examination at the 36-month date. So the deadline for making this request is 36 months from the priority date. IPOS will conduct a de novo search, irrespective of the fact that international search report may be issued for the PCT, and then it'll undertake examination on the basis of that report. It does enjoy a cost and time saving relative to option 1, but in practice we don't see too many foreign applications, originating applications filed into Singapore taking this option up. Option 3 is probably one of the more favoured options. It's a local examination on the basis of foreign search report or search results, which can include foreign search results from a corresponding application or the ISR from the corresponding PCT. The deadline for making this request is 36 months, and the Intellectual Property Office will conduct examination on the basis of those search results. They won't conduct any de novo searching, but in my experience, it's discretionary. They can conduct other searches if they feel that it wasn't robust enough. This option requires that you provide the Patent Office with a copy of the search results from the international stage or issued from a foreign corresponding application. As I said, it's quite a popular choice for applicants filing PCT national phase in Singapore. The reason being is it's quite cost effective and it provides the comfort of knowing that the local Patent Office has examined novelty and inventive step under local law. So in terms of enforcement, you've got some comfort that those patentability considerations have been considered locally. Supplementary examination is option 4. This option's only available until 2020, so it's being phased out in an effort to make applicants rely on examination by the Intellectual Property Office of Singapore. But any application that is filed before 1st of January can take up this option. It is quite popular, particularly where applicants have a large patent family and they want to leverage or streamline prosecution of the Singaporean application with those other applications. The benefit is that you can delay requesting examination until 54 months from the priority date. So, you know, that gives you a bit of time to see examination through in one of the corresponding applications. Following that, examination will be performed for local practice requirements only, so those types of issues like patentable subject matter. They won't consider novelty, inventive step or industrial applicability, and they'll rely on the outcome of examination from that foreign application. So the advantage is that you can delay making a decision until you know the outcome of examination elsewhere and streamline examination in Singapore with the rest of the world. To take up this option, you need to file a request, provide a copy of the allowed or granted corresponding application, the final examination results. you can also base it actually on a clear IPRP as well. So if you've got a clear IPRP, you can rely on option 4 and just got to provide a copy of that clean IPRP. Provide a copy of the claims that are allowed and a claims correspondence table showing that where the Singaporean claims correspond to those that are allowed. For the purpose of knowing which jurisdictions you can base supplementary examination on, a corresponding foreign application is one that was filed in Australia, Canada, the US, Japan, New Zealand, Korea, UK, and Europe. All right, so probably the last point is that for all of these options, Singapore has a very, very generous extension period of 18 months. So like the national phase extension, this is available as of right. So you can extend those provided that you pay the fees up to 18 months. So quite a bit of flexibility on examination. All right, this is again another complicated chart, but this is what we put together is a flow chart for options 2, 3, and 4, because we see that these are typically the examination tracks which are taken up for Singaporean national phase applications. So look, once you have selected your examination route, the Patent Office will undertake substantive examination, and on the basis of that, they'll issue a written opinion. So if no objections are raised, the written opinion will be a clear and a notice of eligibility to proceed to grant will issue. If objections are raised, the written opinion will provide reasons for the objections and set a deadline by which a response has to be filed. The deadline is 5 months for normal examination under options 2 or 3, or 3 months for responding to an examination report issued on a supplementary examination report. So the subsequent written opinions may issue until all the objections are resolved. One thing to bear in mind with the supplementary examination, because they consider that the issues to be addressed will be minimal, they only give you one bite of the cherry. You get one round of examination to address all the issues, and if you don't, then you'll get a final refusal. So if the outstanding objections aren't resolved within 18 months, for normal examination, or 6 months from the date of the first examination report, a notice of intention to refuse will issue. If that does occur, you can request a review, an examination review, which provided that you file a request for 2 months from the date of that notice of intention to refuse issuing. And at that time, you can address it like a normal response. You can file amendments, not submissions, but you can file amendments. And the review panel will be formed. This typically comprises the original examiner and 2 additional examiners, and they will look at the adverse report and consider whether or not you've got a case. If, on the other hand, examination is favourable, a notice of eligibility to proceed to grant will issue. Once this occurs, the applicant actually has to actively request issuance of a certificate to grant within 2 months of that notice of eligibility issuing. If you don't do that, the application will be deemed to be abandoned. So it's not a matter of the notice of eligibility issuing and just paying fees. You actually have to request grant. In our experience, the average pendency of an application once a request has been made is about 8 to 12 months. But if examination elsewhere has proceeded through to grant and you take up the supplementary examination option, we find that we can streamline this and shorten this to as little as 6 months. All right. So I thought it would be worth looking at a couple of the options available for accelerating examination. Look, they don't have a classic classic acceleration route, but they do have a few initiatives which can expedite examination. The first being the FinTech Fast Track initiative. This is relatively new. It's a relatively new initiative of the Patent Office to accelerate applications in the FinTech space. So this goes to Singapore's goal of being a FinTech hub. It's available on applications which are first filed in Singapore. So if you want to make use of this initiative, you may wish to file a convention application in Singapore rather than going through the PCT track. That being said, all it is you're jumping the queue. It's not guaranteeing a favourable outcome. The next option is PPH and GPPH. For those not familiar with GPPH, in Australia we distinguish between PPH and GPPH. So the Patent Office has a PPH pilot program with the Chinese Patent Office and the Patent Offices of Mexico and the EPO. I apologise, I think the slide indicates that it's Japan and Europe. I apologise for that. Patent Office also participates in the global GPPH pilot program, which permits applicants to rely on search results for national applications and PCTs in any of the other 24 GPPH participants. So under the PPH and GPPH programs, you can file a request anytime before examination of the Singaporean application, and it basically expedites examination. Just need to meet the standard requirements of making the request, identifying the application to be relied upon, a copy of the claims in that other application which have been allowed, and a claims correspondence table. So the normal procedure. The third option is the ASEAN Examination Cooperation System, or the ASPEC system, which can be relied upon for applications made to other ASEAN member states. So it's essentially a resource sharing program between the ASEAN patent offices, which allows various offices to rely on each other's search and examination reports. To rely on this, you just have to file a request any time before a final decision to grant or refuse is made. In reality, we see that ASPEC is rarely used and is unlikely to be used for Singapore, simply because examination in Singapore is a lot faster than for other ASEAN patent offices. But that being said, when you're thinking about an overall ASEAN filing strategy, the ASPEC system can be a useful strategy for streamlining examination in other ASEAN countries. So if you are filing into Singapore and you're considering filing in places like Malaysia, Indonesia, you might want to consider using this ASPEC route. So those other patent offices which are a member to the ASPEC system are Brunei, Cambodia, Indonesia, Laos, Malaysia, Philippines, Thailand, and Vietnam. Now, not mentioned here, but the other obvious option is relying on that supplementary examination, which we mentioned earlier. It's not so much a way of accelerating the examination process. You're not going to be jumping the queue, particularly as the deadline's 54 months, but it is a nice way to speed up the examination process once it's begun. Of course, there's nothing stopping you from filing a request for supplementary examination early. So if you've got a strategy where you've entered national phase or you've obtained accelerated grant elsewhere, like in Australia or the US, you can use that to obtain a rapid allowance in Singapore using that supplementary examination route. And again, that's available until the 1st of January 2020. Okay, we are just looking at time, but I might just go through the last few slides on some of the other considerations in Singapore, and I'll try and go through them quickly. Voluntary amendments, generally allowable in Singapore, generally allowable before requesting examination, not between the time you request a search and the issuance of a report. You can do it once examination is commenced, you can file voluntary amendments any time in response to an examination report, and it needn't be responsive to an objection. Narrowing post-grant amendments are allowable, but you know, the typical criteria apply. You can't add subject matter which goes beyond the disclosure of the application, and you can't broaden the claims. However, narrowing amendments, correction of obvious errors are okay. Some consideration might be given to unreasonable delays if your narrowing amendment is going to be used, for example, in infringement to catch an infringer. There was a recent case where amendments were denied because there were unreasonable delays. Divisional applications can be filed any time before grant, before paying the grant fee, and it's possible to daisy chain divisionals. When considering whether to file a divisional application, you need to be aware of double patenting. I think that's something to be mindful of. The general rule in Singapore is that no two patents can claim the same invention. Claims may be considered to define the same invention if they share the same technical feature. So if a unity objection has an issue or you haven't provoked one, you need to be wary of whether or not your claims will be considered to define the same invention. So in a situation like in the US where you have a patent to a composition and then a divisional or continuation to a method of using it or a method of manufacture, that could theoretically provoke a double patenting objection in Singapore. So you need to be wary of that. However, I'm not aware of any situations where they've applied it so draconianly. But be mindful of it. Restoration of lapsed patents applications are possible. It has to be initiated any time before 18 months from the lapse date, and it must be shown that the lapsing was unintentional. This is a lower threshold than the old reasonable care standard. No pre or post grant opposition proceedings in Singapore. It's not possible to reopen examination. This was thrown out with the recent changes. However, you can revoke a patent before IPOS. Previously, parties could also initiate revocation proceedings before the High Court by way of a counterclaim during proceedings. However, in a recent decision has indicated that's not possible, which is quite strange. But again, that's a recent decision, so we'll wait to see if that's appealed. In the meantime, I think if you're a defendant in patent infringement and you're thinking of invalidating a patent in Singapore, you ought to think about commencing proceedings, revocation proceedings before the register, before those infringement proceedings occur. Renewals payable at grant and accumulate from 4 years from filing. They're payable annually. They're based on fixed fees, irrespective of claim numbers, and you've got a grace period of 6 months for paying late fees on renewals. I've got a few slides on enforcement, but look, I might just check in with Greg here to see if you want me to go through the enforcement or whether or not you want to field questions.
It is currently 3:56, so I think we might want to adjust into the question time in case anyone has any of those, and maybe we can schedule an additional webinar in the future to cover those items.
Thank you, Greg. Greg, this is Steve. I can see that we've got a question that's arrived on the FinTech Fast Track program. Lee has covered that briefly. Just a couple more details on that. It is, as Lee mentioned, it's available for direct first filings into Singapore, and we understand that those direct filings have to be actually first filings with no priority claim. So there are a number of requirements. We can forward the Intellectual Property Office of Singapore has issued some reasonably clear guidance on what is expected. Again, it's a fast track system, first filing into Singapore. It has to relate to fintech, and the Patent Office has provided its own definitions of what constitutes fintech. Essentially, their intention is to get an application granted within 6 months. It's a very expedited system. You have the onus to respond to any objections within 2 weeks. But again, part of the overall push from Singapore to establish itself further as a financial hub in the region.
Absolutely. Thank you so much. And if anyone has any additional questions, now would be the time. You can submit them via the chat module on the right side of your screen. Thanks for attending today, and we'll wait here a few moments to see if anyone else has any additional questions. We do have an additional webinar coming up next month on India, so if you have a passion or an interest in patenting procedures in India, please go to the Black Hills IP website and sign up. And I don't see any additional questions, so I just want to thank everyone. Thank you, everyone over there from FB Rice for signing in today. Much appreciated. And we'll see you all next time.
Great.
Thanks very much.
Thank you.
Thank you.